Can my employer stop me from talking about a union? Have you ever wanted to talk with coworkers about forming a union, only to hear your boss say, "You can't discuss that here"? Or maybe management puts up signs warning that union talk is not allowed on company property. The big question is, can an employer legally stop us from talking about a union? The short answer is no, at least not in most situations. Under U.S. law, workers have the right to discuss wages, working conditions, and union organizing. Employers who interfere are often breaking the law. In this video, we'll explain exactly what rights we have under the National Labor Relations Act, what employers can and cannot do, where the boundaries are, and what real cases show us. By the end, we'll know when union talk is protected, when restrictions may apply, and how to act if our rights are violated. 1. Section 7. Our right to talk about unions. The foundation of union rights is Section 7 of the National Labor Relations Act, N.L.R.A., passed in 1935. It guarantees that employees have the right to form, join, or assist labor organizations, bargain collectively through representatives of their choice, engage in concerted activities for mutual aid and protection, refrain from such activities if they wish. Talking about a union, whether in the break room, on a lunch break, or outside of work, is a protected activity. The law recognizes that workers cannot organize or bargain collectively unless they're free to talk to each other about it. Example: a group of retail workers chats during lunch about signing union cards. The manager overhears and tells them to knock it off. That's unlawful interference with Section 7 rights. So, Part 1 makes it clear. Our right to talk about a union is built into federal law. 2. Section 8. What employers cannot do. Just as Section 7 protects workers, Section 8 of the N.L.R.A. defines unfair labor practices, ULPs, for employers. These include interfering with, restraining, or coercing employees in the exercise of union rights, spying on workers engaged in union activity, threatening job loss, reduced hours, or other punishment for union talk, promising benefits to discourage union support. So if a supervisor says, "If you talk about a union, you'll lose your bonus," that's a clear violation. If HR calls employees into private meetings to grill them about who's involved, that's also unlawful. Employers can express opinions about unions, but they cannot threaten, interrogate, promise, or spy. These 4 categories, known as the TIPS rule, are strictly off-limits. Example: a warehouse manager tells staff, "Unions are expensive, but it's your choice." That's legal. But if they add, "If you unionize, we'll cut your hours," that's illegal under Section 8. So Part 2 shows us, the law gives employers limited free speech, but not the power to silence us. 3. Limits and exceptions. When employers can restrict talk. While union discussion is broadly protected, there are limits. Employers can enforce rules about conduct and productivity, as long as those rules are applied neutrally. For example, if a company bans all solicitation during work hours, it can prohibit union solicitation while on the clock. But it must also ban solicitation for charities, raffles, or sales during work hours. Employers may restrict distribution of union flyers in work areas during work times. But workers generally have the right to distribute in break rooms, parking lots, or outside work hours. Employers may restrict access to private property like retail floors to avoid disruption, but they cannot selectively enforce rules only against union activity. Example: a call center prohibits all non-work talk while on the phones. If workers discuss a union during calls, the employer can intervene. But if the same employer lets workers talk about sports or weekend plans on the phones, they cannot single out union talk. So, Part 3 highlights an important point. Employers can regulate work time, but not target union speech unfairly. 4. Real cases and N.L.R.B. rulings. Looking at real-world cases helps bring this to life. Case 1, Republic Aviation, 1945. The Supreme Court ruled that employers cannot prohibit union talk during non-work time in non-work areas. Workers have the right to discuss organizing during breaks. Case 2, Walmart employees. Workers were disciplined for handing out union flyers in the break room. The N.L.R.B. ruled the discipline unlawful because break times are protected for union discussions. Case 3. Starbucks firings. Baristas involved in union campaigns were allegedly fired. The N.L.R.B. found many of these firings unlawful retaliation and ordered reinstatement. Case 4. Company email systems. In 2014, the N.L.R.B. ruled that workers can use company email during non-work hours to discuss union matters, unless there are special circumstances. These cases show a consistent theme. When workers talk about unions on their own time, in their own space, the law strongly protects them. 5. What workers can do if rights are violated. So what if our employer tries to silence us? Document incidents. Keep records of conversations, warnings, or threats. File a charge with the N.L.R.B. Workers have 6 months to report unfair labor practices. The N.L.R.B. can investigate, order remedies, and reinstate workers. Seek support. Unions, worker centers, and legal aid groups can help navigate the process. Stand together. The more workers act collectively, the stronger the protection. Example. A group of employees at a hotel was told they couldn't discuss unions on the property. They filed a charge with the N.L.R.B., which ruled the employer violated Section 7. The workers were vindicated, and the employer had to post notices affirming their rights. So Part 5 makes it clear. If our employer tries to stop union talk, the law gives us tools to fight back. 6. Why these rights matter. Union rights are about more than forming an organization. They're about freedom of speech in the workplace. Without the ability to talk to coworkers, workers could never address issues like unsafe conditions, unfair pay, or unpredictable schedules. Congress passed the N.L.R.A. in 1935 because they recognized this. Even today, union activity remains controversial, but the law still protects the basic right to talk about it. The bigger picture is this. Allowing open discussion balances power between workers and employers. Stopping those conversations tilts the balance unfairly. So, can an employer stop us from talking about a union? The answer is no. Not during our own time, not in non-work areas, and not through threats or retaliation. Section 7 of the N.L.R.A. guarantees the right to discuss, join, or form a union. Section 8 makes it illegal for employers to interfere. That said, employers can regulate actual work time if they apply rules evenly. The key is this. Union talk is protected, but it must respect neutral workplace rules. If your employer crosses the line, the N.L.R.B. can step in. So keep talking, know your rights, and stand together, because our right to discuss unions is the foundation of workplace democracy.